I don't know if we can be shocked anymore. We've seen so much nonsense out of the SEC. I guess we could look at the worst case scenario as being the ruling comes out before September 30th.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
The people want to know, on June 14th, are we going to see those emails? Is it confirmed?
Yes, June 13th is the date that they're going to be released. Now, we don't know what time. It could be, it's always possible, too, that that's a deadline. And sometimes, because we've seen this happen in the case, sometimes they get released a little bit early. So if both sides agree that all their redactions are in and done and comply with the judge's order, is it possible that we get it on the 12th? Which is a Monday instead of Tuesday? It's possible, but at the end of the day, most lawyers meet those deadlines on those deadlines. And the deadline technically would be Tuesday by midnight. So Tuesday, June 13th, sometime we're going to see those limited redacted emails, and which is very important because the next day is the 5th year anniversary of what I believe is the most infamous speech in SEC staff history, and that's the Hinman speech, which is on June 14th, 2018.
So when you say Hinman's emails are going to be released but redacted, what does that mean exactly?
Oh, that's a great question. And if a lot of people remember, it would be the entire sheet would be redacted, every word. And the judge has basically ordered that certain things are private. So, for example, and it's not just the Hinman emails. They are one of the documents. But for example, the experts' names, who the SEC used as experts, their name will be redacted. Certain IP, ODL cells and information will be redacted. Certain personal information of Brad Garlinghouse or Chris Larson will be redacted. But the substance of things will not be. So, for example, if you go to the summary judgment opposition that Ripple filed, they cite one of the Hinman emails, and they say that the director of trading and markets, who we know was Brett Redfern, but said that the speech will lead to, and then it's redacted. So we're going to get to see what he said. Now that lead to, I believe it's going to say more confusion, market confusion, things of that nature. And so we're going to get to see the give and take between these people. What everyone needs to know about the emails is that there are 52 drafts of this speech. I mean, just think about that. This speech was supposed to be this one guy's personal opinion, right? That's the SEC's tactics. That's the bullshit argument that they went with the judge. This is just Bill Hinman's personal view. Yet we know that there are 63 emails that back and forth of all these people, and there's 52 drafts. And so what a lot of people are speculating, and this, I'm not one, I don't necessarily believe that XRP was in one of the drafts and then taken out. But it could be, right? Now it could be, but there are some saying that it could be that big. The problem, guys, with the emails is this. We got Brad Garlinghouse saying it's going to shock people. And when he says that, I think he means the rest of the world, not so much the XRP community, because I don't know if we can be shocked anymore. We've seen so much nonsense out of the SEC, but maybe we will be. The question is, there's been so much built up on these emails. Will they be a little underwhelming, or will they truly shock us? We're going to find out, but it's going to be incredible to see. One thing that I know is XRP was discussed, right? And the question is, how many people said, why even give this speech? Like, if it's going to lead to more confusion, if you're only going to give ETH a free pass and you're not going to mention XRP, like, why give it? And that'll be really the question. And one of my predictions is that the conflicts of interest that Bill Hinman had, are going to even become more heightened, because I think when we read it, we're going to say, then why did you insist on giving this speech?
There's something damning in there. Why haven't we gotten a ruling yet?
Well, everything, you got to understand, damning is a relative term. And so, and a lot of people have to understand, Ripple has never filed a motion that says prosecutorial misconduct, or they've never filed a motion to dismiss because of, you know, selective enforcement or unfairness between ETH and XRP. And so I don't believe there's going to be any. I even said, I'm someone who said Bill Hinman violated the law. I was one of the first people out there saying, look, he got 15 million from Simpson Thatcher. He was an ongoing sharing partner, all of that. And when the Empower emails came out where they told him, you can't even talk to your partners or you're violating the law. And then he did 3 more times just from the SEC emails. Then I was confident to say, okay, you broke the law. That doesn't mean he's going to go to jail. You know, it means that he broke the criminal financial conflict laws, which says that it's a violation of the law if you allow even the appearance of impropriety. So if the conflicts give the public the appearance that there's wrongdoing, you're in violation of the law. Clearly, he's in violation of the law there. You know, but that doesn't mean he's going to go to jail. And so I don't think there's anything in there that's going to make the judge say, oh, I have to give a ruling right now. Right now, we may hear something from her in her ruling. I'm hoping she takes the SEC to task, similar to what Judge Netburn did, where she said, look, you're not having a faithful allegiance to the law. You're making your arguments based on, you just want to win this particular motion, and you're ignoring everything else you've ever said. You know, so hopefully the judge will get in and put some stuff in there that highlights the SEC's misconduct. But that doesn't mean, you know, at the end of the day, guys, even if it's grossly unfair that XRP was highlighted, even if this lawsuit was used as a weapon, like I've said it is from the first day, the judge's job is, did Ripple sell XRP as a security at some point? Right? That's really her job. And she can, you know, if she thought that there was a criminal violation, she might make a recommendation, you know, to the Department of Justice or something, but that could be done privately. But I think people just got to understand, you know, it's relative of how damaging it is. Now, hopefully it's so damaging that she says, you know, even if Ripple sold XRP in the early years before the ecosystem was fully developed, and that technically satisfied the Howey test, they didn't have fair notice, and lets that go to a jury, which would be a complete win. And then, of course, rule that ongoing and future sales of XRP, especially secondary market sales, are not securities.
If she can't make a decision on this court case, what I'd love for you to do is just deep dive into why she's most likely to make a decision before September 29th.
All right. So there's this rule where if a motion, a dispositive motion, such as a summary judgment, if it's been pending longer than 6 months, a judge has to report herself, so to speak, to Congress. Twice a year, there's what's called the 6-month list, goes to Congress, and it lists all these motions if they've been pending longer than 6 months. That 6-month list gets published the last day of March and the last day of September. So September 30th, say. So if her decision isn't out by September 30th, she would go on that list. She's never been on that list, right? And it's like a public shame list. Like, look, I'm shitty at my job. I don't do my job. I let things sit on my desk all day long. Important cases like this. And so I just don't see her ever letting it go past that, where she's going to report herself. Remember, a lot of these judges have ambitions too. So if you want to go to the Second Circuit Appellate Court, or you want to one day be considered for the U.S. Supreme Court, you keep your name off lists like that, right? And so what I said on stage was, you know, I guess we could look at the worst case scenario as being the ruling comes out before September 30th. I think it's going to be before that, but then I'm also surprised that it's taken this long. So.